In this video, we're going to go through the North Carolina offer to purchase and contract that you'll complete as a home buyer in the state of North Carolina. Hey there, my name is Chris, and I really find that it's helpful to take a few minutes and go over the North Carolina purchase agreement before you sign. That way you really know what you're getting into and what some of the different terms and dates mean. Because the last thing you want to do is just tap and e-sign one of these to get it out of the way and then realize you didn't have something aligned properly, or that the expectations weren't properly managed. Now, one quick disclaimer, I'll be going over just a few of the more important things on this form, so make sure to read through it in its entirety and jot down any questions that you might have. So let's hop on the computer and break down some of those important sections. All right, so starting on page 1 here of the purchase agreement, this is pretty straightforward. You have the seller's name, you as the buyer's name, the property address, and the legal description pulled from the tax information card. And this is gonna be the actual description of the property because attorneys do not use street addresses. They actually refer to the legal description. As we proceed down page 1, you'll see this first line here is the purchase price of the property, which is your offer. Just below that is the due diligence fee you'll offer. We'll see more details about this on another page, but this is typically payable via a personal check once the contract is signed. The next line down is your earnest money deposit amount. And then the next couple of lines don't typically apply, but you can see there's a line for additional earnest money, assumption, if you were going to assume the unpaid balance of the seller's current loan, if the seller was offering financing, and lastly, building deposit for new construction. Then on this last line here will be your total purchase price, less any deposit amounts we have for these lines, which again, is usually just your due diligence and earnest money deposit, and then that will leave us with your balance due at closing. Really, this is just sort of a math breakdown for the seller so they know how the funds are gonna arrive. Coming down to page 2, and it starts off with the earnest money deposit. So as you'll see, or maybe know, there's different periods of time. There's a due diligence period, and then there's an earnest money period. So once this contract is ratified, the clock is gonna start ticking on your due diligence period. This is a period of time in which you'll complete any and all inspections on the property, which your agent should help you set these up along the way. But basically, at a minimum, your lender is gonna require an appraisal, and I recommend a general home inspection as well as a pest inspection, also called a WDIR or wood destroying insects report. Your agent will generally help you get both of these things on the schedule, and in the case of the appraisal, you'll pay your lender for that at closing, and in the case of the home inspector, you'll pay for that out of pocket at the time of the inspection. However, some inspectors will allow that to be paid at the time of closing as well. But during your due diligence period, you're gonna wanna kick the tires and do anything you may want to do as your discovery phase and thoroughly look over everything with the home. If for whatever reason you decide to back out during your due diligence period, you will forfeit your due diligence fee to the seller, as this is the fee you're paying them to take the home off the market. So you'll talk with your agent about how many days your due diligence period is gonna be, and this will be how much time you have from the time this contract is signed to kick the tires, get the home appraised, inspect it, and you also wanna have this done within enough time to come back to the seller to give them your findings and say this is what your requests are. Now this purchase contract is an as-is purchase contract. You're buying the home in its present condition with all defects, but you have the opportunity to still ask. So you should do that if the findings certainly reach a level at which you think the seller would be hurt going back on the market should you decide to back out. The next amount period is your earnest money. So this is if you were to terminate your contract during your due diligence period, you would get a refund of your earnest money. If after the expiration of your due diligence, then you would lose both your earnest money and due diligence fee. So both of these fees would go away if you cancel after the expiration of due diligence. Coming down to the escrow agent, your earnest money is going to be held with an attorney in their trust account who will be listed right here. The effective date of this contract is when it's actually signed by both you and the seller. So should there be any sort of changes to dates or terms or amounts or any single line item changes to this contract, that will restart the clock, so to speak, on the effective date. Again, this goes into the due diligence period. We want to make sure that by 5 p.m. on the expiration of your due diligence period, which is the determined amount of days from the effective date, that on 5 p.m. by that date, you feel satisfied to move forward and you're willing to put your earnest money now on the line. Because as of 5:01 on that day, you are now out not only your due diligence fee, but also your earnest money should you decide to move forward. So if there are any loose ends not tied up, or you're not happy with the inspection findings, or you wish to receive more expert advice or quotes, you'll want to make sure that's done during your due diligence. In our current market, getting an extension on this due diligence period is usually unlikely, as sellers feel very confident that their home will sell, whether to you or another buyer. The settlement date, also called a closing date, is the date you will actually close on the home. So you will discuss this desired date with your agent and fill it in here. This is when you actually sign and take possession of the home, likely that same day. If you close late in the day, there is a chance that it may not record until the following business day, and in that case, that will actually be the effective date in which you will actually own the home. Coming down to page 3, if there are any special assessments or anything that's known, they will be paid by the seller. The seller is asked to provide, to the best of their knowledge, any sort of HOA related items or city or county related items that are being charged against the property, and if those are found during the attorney's look back, they will charge those to the seller. Fixtures and inclusions. There are certain items that are definitely included with the purchase price of the property, but the general rule of thumb is anything that is screwed or glued to the property will remain with the home, and anything that is detached or freestanding will not transfer with the property. There are a couple items that sort of fall into a gray area, so like remote controls that work, say the garage door opener, where the garage door opener is a fixture, but the remote is personal property. Those remotes will come with the property. You can also include a list of things discussed prior that you may want to be included as personal property with the home. So the refrigerator, for instance, this is an appliance that's considered personal property unless you write it in. So you would want to go ahead and write that into the contract. If there are other certain items not included with the home that you would like to ask for, then you want to write those in as well. Items leased or not owned is something where we can note here if, say, there was a satellite dish on the roof that is not owned by the seller and they will need to be removed, and say if they were also taking their curtain rods with them, that can be listed here as an item that will not convey. The buyer's due diligence process. This breaks down all of your various obligations in detail. So the first one is your financing and loan. You want to make sure before the expiration of the due diligence period that your loan details are tied up and in a good spot. That's why I encourage working with a good, reputable lender, because they will understand the North Carolina process and make sure that they work through that due diligence period. You don't want that day to expire and still have loose ends to tie up on the mortgage side. The next part B is the property inspection, as I mentioned earlier. A general inspection, review HOA documents, restrictive covenants, bylaws, financials, and those sort of things, which you'll obtain from the seller during the due diligence period. Insurance. It's also advisable to get a cost estimate for insurance on the property. You want to verify its existence in a flood zone, which the lender will also do. The lender will also have the property appraised, and it's also highly recommended to get a survey, especially if you're thinking of adding a fence, landscaping, pool, or things of that nature. You'll really want to get the property surveyed to know exactly where your boundaries lie, and that's even advisable if you don't plan on doing those things. Zoning and government regulations. If you plan to run a business out of the home, this is a great time to tell your agent. Anything zoned residential, you could run into hurdles that way, so let your agent know if there's any unusual use of the property that will be going on so you can check against the zoning rules. Your agent will check the FEMA flood map to see if the property is in a flood zone, which the lender will also do. Utilities and access. You'll talk about this more in length later in the process, but this is not something that usually matters too much. There's obviously the county and city utilities that we've made available to you, and you'll transfer those over before the time of closing. Streets and roads talks about street roads and maintenance. Depending on the property you purchase, if it's in a homeowners association, their individual streets are typically private roads that are owned and managed by the HOA. But if the property is not in a homeowner association, then you'll want to investigate if the street or road is private or public, and who is responsible for the maintenance of it. Special assessments, as I mentioned before, if there are any special assessments, they'll be disclosed to you in the property disclosures, so you want to go over those if they exist. And if there's a fuel tank on the property, the fuel charges will be prorated and the owners of the tank will generally transfer with the property. Repair, improvement, negotiations agreement. This reiterates the fact that the property is sold in its current condition, so any improvements are not the seller's obligations to make during due diligence. You can ask for things, but you would have to have the improvements signed and agreed upon, and negotiations ended by the conclusion of the due diligence period, which is 5 p.m. on that last day. The buyer is obligated to repair damages that you, your agent, or any contractor make. So if you have an inspector that comes in and poked the holes in the walls or things like that, you would be expected to make those fixes if you were to back out the contract. Should you wish to terminate the contract at any time, you just need to have a form signed saying that you're going to terminate. And again, if it's after the expiration of due diligence, that form is going to terminate your due diligence fee and your earnest money. If it's during your due diligence period, you will get your earnest money deposit back. So it's really imperative to make a decision during that period. Buyer representations. This is your representation as it relates to financing. If you're paying cash, you would check this first box, or if you're getting a mortgage loan, you'll check this second. If it's a mortgage, here you'll disclose to the seller what your intentions are for a mortgage. This doesn't have to be the exact product that you land on, but these are your goals or intentions based on your initial pre-approval letter. And again, this would be subject to change. If you have any sort of contingencies as it relates to selling or leasing other properties, you'll put that here, but there is a no sale contingency in the state of North Carolina. This is more of a disclosure just to the seller, so know that as you move forward. The residential property and owners association disclosure disclosure, you'll typically be checking the first box to say that you received an acknowledged receipt of the North Carolina property disclosure. It's important to look it over and make sure the seller has made no representation on that form of any sort of issues that they know of. The mineral oil and gas rights is also a disclosure that you'll receive and want to go over with your agent, so you'll check that box. Your buyer obligations as it relates to this whole process is to move forward with your due diligence related costs and items, and to basically make sure that you're satisfied with the findings and outcomes as you move forward. Seller representations starts off with how long the sellers have owned the home. Your lender will also ask this, as it can be in part with anti-flipping or basically like a fraud kind of rule. So if they've owned it more than a year, that helps to not raise flags when the lender moves forward with the lending process. If the property is built prior to 1978, this box will be checked and there will be a lead-based paint or hazard disclosure addendum to review. Owners association and dues will be checked here if the property has a homeowners association, and if so, the dues will be listed here, as well as the name, the association, and website if applicable. Some of the seller's obligations will be to provide evidence of title, that the loan will be paid off at closing, and that everything will move forward, which will flow directly through the attorney. They will provide reasonable access to the property prior to closing, allowing you, the buyer, the opportunity to conduct due diligence, verify the completion of any negotiating repairs or improvements, and conduct a final walkthrough inspection prior to closing. They again have to provide a general warranty deed, which the attorney will take care of all of this, but basically this is the best deed type in North Carolina, as it provides against claims from previous owners and will provide that the deed is free of liens and encumbrances once you're the owner. The deed, taxes, and fees will be your name or names listed here that the deed is to be taken in. Agreement to pay buyer expenses. This would be if you were asking for any seller paid closing costs, which are very uncommon in our current market today due to it being very competitive, but if there were any seller paid closing costs, they will be listed here. Proration and adjustments basically breaks down that the seller will be responsible for the prorated amount of any taxes through the settlement date, and they'll be either adjusted between parties or paid at closing. If there is a home warranty being offered or you are requesting one, it would be checked here. These are also very uncommon in this market, but you are free to purchase your own home warranty before closing. Coming down to page 11, any other addendums to the property sale will be listed here, like any additional provisions if obtaining FHA or VA financing, or the lead-based paint hazard mentioned earlier, etc. This is typically not a tax-deferred exchange, however there would be additional documents including assignment of this contract if so. And then page 12 really just gets into some of the legalese as far as outlining terms and things like that. And then here on page 13, you're going to sign as the buyer and date. And with most any agent you work with, you'll probably be prompted for e-signing blocks through either zip forms or DocuSign, which are e-signing providers. You'll typically leave these buyer and seller notice addresses blank because the attorney and everybody will go straight to your agent for any information they need, so that you're not bothered by unnecessary email or mailings. And here will be your buyer's agent information, who is representing you as the buyer, and the listing agent, also known as the seller's agent's information, will be provided right here. Once your due diligence fee and earnest money is received by both the seller, their agent, and the attorney, they will sign and acknowledge receipt of those here. So we will give this to the lender, and that will provide proof that the contract is bound and the funds have been received. And that is the North Carolina offer to purchase contract in a nutshell. If you have any questions or would like to know how I can help you with your home purchase, please reach out and we can talk further. But with all that said, we'll wrap this video up. If you enjoyed it, I hope you would give it a like and leave a comment below if you've recently purchased a home in North Carolina, and let me know how your experience was. If you're interested in coming along my journey as a real estate agent, or for more videos like this, I hope you'll consider subscribing. But let's make every day count, be more than average, and I'll see you in the next video.